Deshpande ma'am to extend a warm welcome to our judge for the event, Honorable Srimati Justice M.S. Savalkar, with a shawl, memento and a gift as a token of our love and gratitude.
Joining Justice Zavalkar, we have Honorable Shri Justice Anil Lakshman Pansari, also a judge of Bombay High Court. With an academic foundation in science, business management and law, Justice Pansari has served as Principal District Judge in Beed, Amravati and Thane. His Lordship was elevated to High Court in 2021 after an admirable tenure as Registrar in Supreme Court of India. Now I request Shri Dinesh Shedam sir to welcome Honorable Justice Shri Anil Lakshman Pansari with shawl, memento and a gift as a token of our gratitude and appreciation.
With us, we have a special guest, Shri Dinesh Shedam sir, a Senate member and a former Management Council of the University. I request our Principal, Dr. Ravi Shankar Moore sir, to honor sir with a token of appreciation. With this, let us prepare to witness the brilliance of today's finalists as they argue with passion, precision and purpose. Let the proceedings of the trial advocacy final begin.
वगैरे हां मुद्दामच ठेवलेले आहे.
लॉन्ग प्रेस करू.
हां मी सांगितलं त्यांना ऑलरेडी ब्रीफ केलेलं आहे.
Prosecution, may please address the honorable bench and seek permission to begin the proceedings.
The council seeks permission to address this honorable bench as your lordship. The council seeks permission to address this honorable bench as your lordship. Much obliged, my lordship. Lordship, the facts of the case. In this present matter, I, along with my co-counsel, are appearing on behalf of the prosecution. My lords, in the beginning of the opening statement, I state the facts and then proceed with the submissions. My lords, Raju Munir, Manu Singh, Dilip Sutar, Shantanu Murthy, along with the deceased, went on a trip to Amgaon. My lords, if you may proceed. Much obliged, lordship. The accused, with the deceased, went on a trip to Amgaon to visit a Durga Mata temple. It was meant to be a holy trip. The deceased also took the permission from his father that he wants to go. They all traveled in the car, Baleno, and traveled to Amgaon. There is no record to show that the accused and the deceased went to the Amgaon temple. They took a detour from that and lodged in a hotel named Seva Kunj on 28/10/2024. Therein, they were seen in the hotel lodge. After they checked out, they had a little argument with the lodge owner about the extra charges on that regard. After that, they again went on and joined another highway, and then at the evening, they lodged into another hotel named Hotel Darling. Therein, they were last seen by the service boy. The service boy saw two accused with the deceased, strangled them in the bed, and that shows the intent and the malice of this prosecution, of the defense, or the accused on this regard. My lords, going in the background of this case, the 5 accused belong to poor financial background. They have the aspiration to become rich by adhering to some criminal activities. They also have past antecedents. The principal of their college have received certain complaints of minor theft, other illegal activities that they were doing, some drug trafficking activities as well. My lords, after this, also before entering into the Hotel Darling, the Raju Munir, the present accused number 1, he took the SIM card owner's shop. Then they also went to restaurants and other petrol pump restaurants where they used fake credit cards.
Are you able to hear backside? You can hear without mic, no? Okay. You may come forward if you so wish. Sir, live streaming is going on.
Hello.
Mic is necessary.
No, sure. My lords, then they have taken out certain credit cards and the payments for that particular matter. They All 6 of them had lunch in a particular restaurant and they filled petrol pump. Raju Munir was identified in the CCTV footages that he filled the petrol pump in the Baleno car. SIM card owner in his statement has stated that he saw Raju Munir coming into the shop, buying the SIM card, procedure has been followed, and the deceased was also seen by the SIM card owner in the Baleno feeling unwell and in his regard. In the evidence matter, this all will be dealt with. Secondly, my lords, their aspiration to become rich, they belonging to poor family, their aspiration to become rich is also a matter of fact. They have initiated certain illegal sorts of mind. My lords, when this all happened, there lies evidences on that regard that they were last seen by the service boy when the 2 accused, along with other accused, the 2 accused were doing the act of strangling him in the bed, and then from there, they were never seen after that. And the deceased body was found later on 22nd 10/2024 by a farmer in the river bank. The deceased body was floating in that, and then the whole Panchanama and investigation, all that regarding has been sorted out. The father of the deceased, my lords, has received a ransom call of 15 lakh rupees. This is one intent where kidnapping for ransom, the offense of kidnapping for ransom suffices on this. My lords, a prudent man will not call from his own mobile number to take a ransom money. He will definitely do something to take a fake Aadhaar card, fake SIM card to make a call and do the arrangements. And my lords, that suffices where he bought, the Raju Munir accused number 1, bought the SIM card. After this happened, the whole incident took place. When the ransom money has been collected by the accused, they all thought that this is a nice idea. Now they will be completely devastated if this goes out in the public. Then they all decided to kill the deceased in order to just stay away from this ground and nothing will happen. My lords, it is also prudent enough to say that when a person has gone missing, as stated in the statement in the investigation process by the accused, that we searched for the deceased for a day or so in the morning, but we couldn't find, and then we left to our home. This is also a complete lie, my lordship, because a prudent man will do something, make calls to the parents, has he reached there, where is he, till a decent amount of efforts will be taken in regard to file or search for him. But that hasn't been explained or given any evidence for that regard. But the last seen theory also applies in this particular fact that service boy last saw them, strangling the deceased in the bed, and then the deceased body was found. These are the opening statements, my lords. Rest will be dealt in the evidence matter when the chief examination of prosecution side witnesses will be done. My lords, if may kindly proceed with the defense opening statement.
Counsel seek permission to present opening arguments. May it please the court, I, counsel number 1 for the defense, represent the accused, Mr. Raju Munir, Mr. Manu Singh, Mr. Dilip Sutar, Mr. Shantanu Murthy, and Mr. Prakash Hegde in this incident case. We stand before this honorable court to contest the charge brought against the accused under the section 103, 114, 111, 126, 303, 305, 115, and 61 of the Bharatiya Nyaya Sanhita 2023. The charges levied against my client under the said section of Bharatiya Nyaya Sanhita include allegations of murder, kidnapping for ransom, organized crime, wrongful restraint, theft of vehicle, and criminal conspiracy, Your Honors. However, as we delve into the facts and evidence of this case, we will demonstrate that these charges are based on weak circumstantial evidence, procedural lapses, and assumptions that do not withstand with the scrutiny of law. At the outset, I humbly remind this honorable court that the principle of the cardinal principle of justice, which is every accused is presumed to be innocent until proven guilty. In this instant case, the prosecution has failed to prove the beyond reasonable doubt that the accused had committed the alleged crime. In this case, the prosecution has failed to meet this burden, Your Honors. Your Honors, the prosecution claims that my client has kidnapped the accused. My clients have planned to kidnap the classmate, Mr. Suhas Chandra, and later murder him to extract a ransom from his family. While these allegations may seem grave, they are unsupported by the concrete evidence. The prosecution relies predominantly on the circumstantial evidence, inadmissible confession of Shantanu Murthy before the police custody, and the speculative connection that fails to prove guilt with certainty. Your Honors, as the Supreme Court held in a number of cases that suspicion Suspicion, however strong, cannot replace proof. We, in course of this trial, proved that prosecution has failed to establish any substantive case against our client. Much obliged, Your Honours.
Your Lordship may kindly grant the opportunity to chief examine the prosecution witnesses. Before delving into the chief examination, my lords, as counted by the opposite party, that circumstantial evidences are based on relying the prosecution side. My lords, on this regard, I would like to present the pioneering judgment on this regard that convictions can be granted on circumstantial evidence. 5 guidelines by the Honorable Supreme Court of India has been added in this regard in the case of Sada versus State of Maharashtra. The Panchashil guidelines, as Your Lordship may be aware of. If Your Lordship may kindly please that if the prosecution can submit the case laws for that matter. Your Lordship, the golden 5 principles on this regard has been elaborated enunciatedly by the Honorable Supreme Court in the page number 185 of this judgment, Your Lordship, as the courtesy copy has been provided to you. $185, my Lordship. 185, my Lordship. If Your Lordship may please, I would like to reiterate the points. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is long and divides vague conjectures from sure conclusions. Second point, my lord, the fact so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. This point also, my lord, suffices on the issue that prosecution will rely on certain establishments where the guiltiness of the accused will be provided with throughout the evidence procedure. My lords, on the third point, the circumstances should be so conclusive in nature and tendency. On this point, my lord, chain of events, there is no break of chain of events, and even if there establishes that the break of chain of events has happened, there is no explanation so probable as to be supplied by the defense. If this may go on for the evidence stage, this can be counted on that. Fourth point, my lord, they should exclude every possible hypothesis except one to be proved. And last point, there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. This is the established principle that the Honorable Supreme Court has guided on. And on relying in this based on circumstantial evidences, the prosecution can rely on the case and conviction can be granted, if followed by these guiding principles by the Honorable Supreme Court of India. If my lordship may please, the prosecution would like to continue with the chief examination. Highly obliged. The first witness to be examined is, my lords, the PSI for this matter.
I, Karamchand Bakshi, do swear in the name of God, solemnly affirm that the evidence which I shall give before this court, shall be the truth, the whole truth, and nothing but the truth.
Please state your name before this honorable court.
I am Karamchand Bakshi.
What is your designation?
I am the PSI of Perugaon.
Please elaborate on the investigation that you have conducted for this particular matter.
On 22nd, my lords, the father of the deceased person, Mr. Chandak, came to the police station to lodge a missing report of his son. Later on the next day, on 23rd, we received a phone call from Borgaon that a body was discovered. Mr. Chandak went to the place where the body was recovered, and later on we investigated the case based on the father's statement and submitted our reports.
Further on, in the intricacies of it, can you please elaborate more on the investigation that you have done regarding the witness statement and other procedures that you have followed up?
After the investigation began, we initiated by calling the accused persons, and the accused persons gave their confession right away. Mr. Shantanu, he was the person who confessed in the police station. Based on his confession, we started the subsequent investigation and joined the dots that were linked to his confession that were clearly found through our investigation.
And what is about the deceased body that you have found out? What has happened with that?
The deceased body was sent for the post-mortem, and in the post-mortem report it was stated that the cause of death was strangulation.
Are you aware that there is certain credit cards that have been used as stated in your investigation report? Please elaborate on that.
Yes, I am aware 2 credit cards were used, and we are of the belief that they were stolen by the accused persons.
Also, do you have any evidence of the accused to be seen with the deceased person?
Yes, the father stated that when the deceased person left for the trip, he stated that he went with his friends, and the deceased person accompanied him, which was seen by the service boy and also in the CCTV cameras.
There are 3 evidences are to be found. Firstly, father. Second, CCTV footages and the credit cards that have been taken off. Service boy is another primary example for that particular matter. My lord, the chief examination for this will be rest. Open for the process.
Cross-examine the witness. What is your role in this case? Can you please elaborate about it?
I am the investigation officer.
And what is your rank in the department?
I am the PSI.
Have you, the CCTV footages which you mentioned, may it be about CCTVs from Seva Kunj Hotel or the petrol pump, have you submitted those CCTV footages transcripts to Honorable Court?
Yes.
The transcripts are submitted. Your Honours, we have not gotten the evidences or the transcripts of CCTV footages. The electronic evidences which are supposed to be presented to this Honorable Court are admissible only when they are not fabricated. And for that, section 63, you are PSI, you must be aware about the submission of
Objection, suggestive answer. You are asking a suggestive question that will hamper the witness's credibility and their own opinion in this matter. You cannot suggest.
Your Honours, I am not suggesting anything. I am just asking about the credibility of CCTV footages to which prosecution is relying upon. Further, you stated that the CCTV footages clearly saw accused. Is that correct?
Correct.
You saw faces of all the accused or only one accused?
I am not clear of the fact.
You are not did you saw any face of any accused in CCTV footage?
Mr. Raju's face was evidently clear.
In which CCTV footage you saw Mr. Raju's face?
Near the petrol pump and the toll booth.
You talked about the credit cards in your statement. Those credit cards belong to whom?
One credit card belonged to Zafar Ali and the other credit card belonged to Mr. Harshad Mehta.
Have you submitted the financial records or bank statements of these credit cards to Honorable Court?
Your Honors, we've asked for the all transcripts and the documents to the bank, but they are under process and are to be submitted.
The vehicle which was used for this trip by accused is blue car. You mentioned that in your statement.
Right.
So who owned this blue car? Do you have any submission about that?
Mr. Preshankar Rao.
Mr. Preshankar Rao. And are you submitting to this honorable court that it is a stolen vehicle which accused stole? Is that correct?
We are under assumption for the same.
You are under assumption that the vehicle was stolen. Is there any stolen report mentioned by Mr. Rao, or did he file any FIR in police station about it? Have you inquired about it?
It is under investigation.
It is under investigation.
Objection argumentative. There is no statement presently of Preshankar Rao. You cannot speculate.
No, Your Honors, I am not speculating anything. The car which the IO has stated that the car was stolen by accused. Your Honors, if car was stolen, I am just on the point that is there any stolen report or is there any FIR which was given by the person who owned the car itself?
Objection. The statement was suggestion. We believe that the car was stolen, not that she has said that car was stolen.
Your Honors, I am the point. Your Honors, I am the point that there are many assumptions made by IO and there is no concrete evidences provided for this assumption, and that is what I want to make sure from this cross, Your Honors. You mentioned that the ransom money was transferred by deceased father. Is that correct? How much money was transferred?
15 lakh.
And this transfer is made by UPI or bank. What was the mode of the transfer of ransom money?
By the bank.
By the bank. At what time the money transferred?
After the call, between 4 to 6 p.m.
4 to 6 p.m. Have you submitted any records of bank statement of father of deceased to the Honorable Court?
I am not clear of the fact. I am not clear of the fact.
You mentioned that the call for ransom was done by the BSNL SIM cards which was purchased by accused. Is that correct? So have you submitted any call records of those two BSNL SIM cards which was brought by accused?
The same is under investigation.
The same is under investigation. Have you submitted any call records of the deceased father who received the ransom call to the Honorable Court?
That is again under investigation.
What was the time of death of deceased?
According to the post-mortem, it is between 8:30 p.m. to 12:30 a.m.
And is it mentioned in the post-mortem report?
I am not clear of the fact.
At what date the deceased was killed?
On 22nd and the night of 23rd.
On the night of?
It was according to the investigation, it is 8 p.m. to 12:30 a.m. So 22nd to 23rd.
Who called you about the body was found in the river bank?
We received a phone call from the Borgaon police station.
And you took someone with you to identify the dead body?
No, the father was called from our station and he went alone for the identification of the body.
And then at what time body was sent to postmortem?
I don't remember.
While you take the possession of the dead body, did you find any evidences, may it be fingerprints, DNA strands of any person with the body? Did you collected any evidences?
Objection.
Relevance. It is highly
the responsibility of the police. It is the responsibility of other state machineries to take care of DNA and other sampling.
Your Honors.
This is badgering. She is trying to manipulate the witness to give a statement that is not what the witness believes in. It is not the responsibility of the police to take care of DNA sampling. It is entirely of a different state machinery.
Your Honors, I am not point of proving that fingerprints are matched to someone. I am just at the point that when the body was discovered by a villager or after the Borga. Your Honors, last one question and I... Highly obliged, Your Honors. Did you present all 5 accused before the magistrate within 24 hours? Have you presented accused before magistrate after arresting them?
No.
That's all, Your Honors. That's all.
Prosecution would like to begin with the chief examination of the service to investigate.
Your Lordship, Your Lordship, the last statement given by the PSI, the question stands to have been objected on the grounds of improperly laid down opinion, as the question clearly did not ask was the person arrested or it was the question regarding the magistrate. I would like to satisfy the Honorable Courts, the answer was regarding the magistrates and not about arrest. The point of arrest still stands unsettled.
Then you should have re-examined the investigating officer.
Your Lordship, the statement will come into our favor while closing arguments. Much obliged, Your Lordships.
I, service boy, do swear in the name of God, solemnly affirm that the evidence which I shall give this before the court shall be the truth, the whole truth, and the nothing but the truth.
What happened in the hotel? Can you please elaborate?
Yes. My lord, on 21st, the 6 individuals entered into the hotel. One of the boy ordered glass and water. As usual, I was working. I received the call, picked up call. He said that give me water and glass. I went to the room. I saw a boy was pinned down on the bed by the 2 boys, holding very tightly. I was scared. I just kept the water and glass. I went out of the room. I immediately narrated to the owner. Owner said that they are the good customers of ours, so don't focus us on that, be engaged in some other work. So as usual, I was in my work, so I was not concentrated on that individuals. That's it.
When have you been working in that hotel?
Around 1.5 years.
So this was this a usual activity in your hotel? Or
No, not at all. So
what did you feel when you saw that?
the boy was very asking for the help, but I was scared, so I immediately went out of the room.
After that, what was the whole investigation and all? What did you state in your statements?
I said it to that the 2 boys were holding very tightly to the.
Were there any CCTV footages that have been extracted from the hotel?
I don't know.
You mentioned that you saw 2 accused pinning down the deceased.
Yes.
Can you identify them?
No, but I can identify the boy because I was very scared and I was seeing that boy that he was pinned down.
Do you know the name of all 6 people who were staying at the hotel?
Yeah, of course, because we haven't recorded, so we know that the FLC. I can identify.
And you conclusively know that the person who was pinned down was Suhas only and no other person?
Yeah.
If shown, can you identify all 6 persons by their names?
I don't want to now. I don't want to identify now.
Okay. Who called you for the order of water and glasses?
Raju.
When you entered the room, how many people was present in the room?
6 individuals.
6 individuals. And do your hotel have policy that you give a hotel room to 6 individuals at a time?
No.
So they only booked 1 room, is that correct?
Yeah.
Okay. You delivered the water from outside the room, or you entered the room?
I entered the room, I placed the water in glass and I went out of the room.
And did you hear any conversation between accused or deceased at the time you were present there?
No.
Was there any retaliation from the person who was pinned down?
Yes, he was scared. Actually, like I can say, he was asking for the help.
To you?
Yes. No, not to me, but he was just seeing me, and I thought that, I was thinking that he is asking for the help.
You thought that he is asking for you. When you reported this incident to the owner of the hotel, he told you not to worry about that.
Yeah.
If you were so scared and you thought that there is something suspicious, why didn't you take any other actions after this also?
I was engaged somewhere else because I have many customers, so obviously I will be engaged in.
So was this so casual of an incident that you forgot it after 5 to 10 minutes?
Yeah.
No more questions, Your Honors.
Thank you, sir.
The next chief examination would be for the PW3, that is this SIM card owner. Three witnesses were from the prosecution. This one was the last one.
I, Suraj Joshi, do swear in the name of God, solemnly affirm that the evidence which I shall give before this court shall be the truth, the whole truth, and nothing but the truth.
Please state your name.
I am Suraj Joshi.
What did you saw on that particular event? What happened?
My Lordship, on that day, a car pulled up in front of my car and a man came out of the car. His face was all covered. He had a mask and a cap on his face. When he came, he asked me for 2 BSNL SIM cards. I asked him to give me some identification of his. Then he presented an Aadhaar card. It seemed a little shabby and not belonging to him. To me. Then I told him to remove his mask. When he removed his mask, his face did not match with the photo in the Aadhaar card, and I asked him, why are you presenting such an Aadhaar card? He told me that he is buying the SIMs for one of his friend, and he pointed out to his car where a person was lying, and I felt that the person was ill or unconscious. Then he said that they were in a hurry as his friend was unconscious or feeling ill. Thus, I gave him the SIM cards and then he went. It was a very brief conversation. He was really in a hurry situation.
Did you see the person who dropped in your shop, his face and anything?
Yes.
How did you see that? What is the whole process?
The one who came for the bill, yeah, when I asked him, he only lowered his mask, not the cap, so the face.
This is the rest for the chief examination for the PW.
You mentioned that 6 people came in the car. Can you elaborate what
I did
was
not mention
in your statement to the police? You stated that the person who bought the SIM card came from the car and car is parked in front of your shop.
Yeah.
Objection, Your Lordship, the statement was not exhibited by either parties, cannot be used as...
In chief examination also, Your Honors, right now...
The statement was not discussed, nor ever the witness stated about 6 people being inside the car, and the police statement does not bears any situation thereof in the witness cross-examination. Using this should be off record, because it was not exhibited.
Your Honors, if I may stick with the statement which Your Honors, So the car which was parked before your shop, which car it was?
It was, I cannot state the models. I am not much aware of car models.
Okay, the color of the car, if you remember?
It could be at least shade of blue or black something.
Do you remember how many people were present in the car?
No.
Why you found the Aadhaar card suspicious? Was it the name or the photo, or what was the suspicious about Aadhaar card?
I mentioned earlier it was the photo which did not match.
Photo did not match. You still went ahead and sold the 2 BSNL SIM card.
Yes.
Despite the fact that you found Aadhaar card suspicious.
Yes,
Is that
I am
true?
explaining.
Yes, please.
The one who came to purchase the SIM card told me that his friend was ill and they were in a hurry. Thus, I did not bother the person who came for the SIM card.
Are you aware about the fact that while you sell SIM cards to someone, you have to take the biometric fingerprints of that person?
Objection, self-incrimination. My witness does not have to answer anything that might perjure her into any
Your Honor,
kind of illegal
I have right
activities.
to ask questions about
She
that.
has the
Your
right
Honor.
of self-incrimination. She can deny the answer.
Yes, she obviously can deny the answer, Your Honors. I am just using my right to ask the question about it, Your Honors. The SIM card which you sold, do you remember that if they paid some extra money to purchase the SIM card?
The money which was given to me.
Objection, compounding question again can lead to self-incrimination. The
Your
witness
Honors,
does not
she
have to
will
answer
deny
this.
that, simply deny that, Your Honors. She can simply say no. I have right to ask.
Article 20, clause 3, right against self-incrimination.
Yes, did they give you extra money to buy the SIM cards?
The money which was given was more than what is the normal, what can we say, amount which is required for 2 SIM cards.
And you accepted that bribe?
No.
You returned that bribe?
I returned, but he did not take it.
He did not take it. So ultimately the bribe is still with you?
No, because he was in a hurry and he did not take it. I did not accept the bribe.
Okay. Did he paid any money for the recharge of these SIM cards, or the recharge was with the SIM card itself?
There is no such extra charges.
There is no such extra. No further questions, Your Honors.
Counsel seek permission to call upon Raju Munir for chief examination. Accused number 1. Please state your name and occupation.
Your Honor, my name is Raju Munir. I am a student of Commercial Arts at Kalaniketan Mahavidyalaya.
Can you state the planning of the trip?
Your Honor, I remember when we were all sitting together, somehow the plan came up. I don't know who initiated it, but it came and we decided to take darshan of Goddess Durga.
What happened during your stay at Seva Kunj on 20th October?
Objection leading. Your Lordship, chief examination, the questions cannot be suggestive. What happened on 28th night in that Seva Kunj hotel? It is clear-cut leading question.
There are so many answers, it cannot be written.
Your Honor, we checked into the hotel at 8 p.m. and we checked out at 12:30 p.m. There was a minor argument with the staff that we overstayed at the Seva Kunj hotel. We were not aware of timing of checkouts, but that issue was resolved by the manager or the owner of the lodge.
Did you call the father of the deceased for ransom?
No, Your Honor.
Objection leading.
Did you ever try to restrain Suhas from moving around?
No.
Objection leading.
What happened at Darling Hotel on 21st October?
Objection leading.
The earlier two were leading, yes. This is why.
Your Honor, on 21st, we were quite tired while we were traveling throughout the day. We had a lunch, so Suhas told me that he needs some fresh air after lunch. So he went for a walk and then did not came back.
That's all, Your Honors.
The counsel seeks permission to approach the witness for cross-examination, Your Lordships. The counsel seeks permission. Much obliged, Your Lordships. So, can you state your name for record again?
My name is Raju Munir.
What is your relation with the deceased?
Your Honor, he was my good friend.
Good, better, best friend, what?
He was a good friend. Yeah.
Good friend of yours. How many years of friendship?
Your Honor, it was 2 or 3 years, Your Honor.
Was he sitting at the time of you guys preparing the trip or not?
Yes, Your Honor.
Where was the planning? Where was the planning taking place?
In the college, Your Honor.
While the classes or after the classes?
Your Honor, after the classes.
What is the timing of your college?
12:30 to 5.
Name of the college?
Kala Niketan Mahavidyalaya.
You went to the father after taking permission?
Sorry?
You went to his father to take the permission?
No, Your Honor.
You guys did not?
He took it himself.
He took it himself. You went to pick him up for the trip or not?
Yes, Your Honor.
Okay. Tell me, what happened at the time you went to that hotel? The second hotel.
Second hotel. Your Honor, we had a lunch. We were, as I said, we were tired. We were quite tired, so we just had a nap. And then he told me that he needs some fresh air, so he went and never came back.
Timing of he going out?
It was around 10 to 10:30. The incident took place 2 months ago, so I'm not sure about the timings.
How many SIM cards did you buy?
2 SIM cards, Your Honor.
Why 2?
Your Honor, we were 6 people traveling, so it would be convenient for us to contact our parent. That is why we purchased 2 SIM cards.
You got the SIM cards recharged then again?
Yes, Your Honor.
Okay. Who had the second SIM?
Suhas had.
You called him? If he was not to be found,
yes,
you called
Your
him?
Honor, we called him. We tried to call him.
Your call record was taken by the police or not?
No, Your Honor.
No? Did you inform them that you called them?
Yes, Your Honor.
What happened in the morning when he was nowhere to be found?
Your Honor, we went to nearby police. We tried to search by ourselves. Then we went to nearby police station. The police officer told us that come after you look by yourself, and then after 20 hours come to lodge complaint.
Come to the lodge and complain. Okay.
Police station. Sorry.
No, the answer was completed. You cannot add when I'm asking the next.
I'm mistaken.
No, you can again. No. Objection of what?
You stated that you cannot add the answer.
Objection of what? It has to be objection of relevance, speculation, what?
Yeah, you cannot really interact among yourself.
Apologies, Your Lordships.
There is objection that we can add, and we can add.
Apologies, Your Honor. It came to police station, the inspector said.
What happened afterwards?
Your Honor, we tried to look for him, but we thought that he might have some emergency, so he went back. So we went to our Perugao, our place of residence, and the next thing we knew, we were arrested for his murder.
When you went back, you called his father or what?
We were about to call him. We in person wanted to tell him that his son is missing, but the moment we reached, police arrested us.
Now the last question. What happened in that room where you guys were doing something? What was that something?
Your Honor, we were playing. Everyone was playing. So it was a playful game. So we were playing only.
With the rope?
No, Your Honor.
Okay.
You are excused.
Am I? Thank you.
Your Lordship, the counsel from the side of the prosecution is taking permission to initiate with the closing arguments, if the Honorable Court may. Much. Except for that, Your Lordships, in the Court of Sessions Jalal District, Shantanu, who is the accused in this case, has in front of the magistrate accepted to be an approver for the prosecution and is willing to give a statement from the side of the prosecution. If the honorable courts may please go through the said order. It is an application from his side that was presented to the district magistrate also.
Your Honours, this application never came to us. We have no idea about the Shantanu will confess to the court, and he was never presented before magistrate also, Your Honours. So we have no idea about this witness being examined.
The point of magistrate was already objected.
Yes, I am telling that the application which you right now submitted never came to our side. That's the point.
It is not from our side, it is from the accused. It is still under the deliberation of the honorable court. If the court may accept it.
I just made my objection to honorable court.
Apologies. If the honorable court may allow, Shantanu wants to be a witness and from the side of the prosecution to give his statement.
Otherwise not admissible at this stage. Strictly speaking, it is not permissible at this stage. But for the purpose of today's trial, we will allow it.
Much obliged, my lordships. I would like to call Shantanu, who is an accused in the crime.
Question for the chief examination.
I, Shantanu Murthy, do swear in the name of God, solemnly affirm that the evidence which I shall give before this court shall be the truth, the whole truth, and nothing but the truth.
Please state your name again before this honorable court.
My name is Shantanu Murthy.
Please elaborate on what has happened at that night.
After we had checked into the Darling Hotel, Suhas and our friends had some dinner, and then Suhas requested to go for a stroll, a little stroll, as he had this habit of strolling after dinner. So we said that we shall also join you, but he said that no, I will come in a short period of time.
When did you last see Suhas? What has happened with Suhas?
We saw him last when he was going for the stroll.
Objection, witness turned hostile. You are excused.
The witness has changed the statement given to the police and the statement given to us and the statement given to the magistrate for the application. As the witness is changing the statement, from the side of the prosecution, the witness stands objected on the grounds of hostility.
I am just telling the truth, my lord.
The moment you were excused, you cannot continue. The prosecution asked for the permission to continue with the closing arguments. Much obliged to your lordships. Lordships, the defense did not object the FIR, the authenticity of the FIR, nor they objected the authenticity of the post-mortem report, thus proving the point that they accept the authenticity, because if you want to object, you have to object on the right time. So if we take into consideration, Your Lordship, the FIR, the time of the FIR clearly states and matches with the statement of the last seen theory of the service boy, stating that I saw them, I feared because there were 5 people against me, and we saw in what condition the service boy was. In this situation, the most prudent thing a service boy can do is to go and inform the person in charge. If the person in charge is not again supporting the same, the service boy said, okay, maybe if something happens, I'll see. And the service boy's statement clearly states, police came to me and said, what happened that day? Then service boy, knowing that now he's safe, she's safe in this argument, gave everything what the service boy saw. Thus proving the point of the last seen theory, there are 2 things to be proved in last seen theory, Your Lordships. First, the relation of the victim and the perpetrator. That happens to be friends. The second thing is there any enmity between both the parties? The enmity word, Your Lordship, is not specifically between parties, but also the background. In this present scenario, the victim or the deceased in this situation was a son of a wealthy person. A person who had no antecedents whatsoever in the entirety of his past life. Nothing to prove that he had some bad intentions or anything. But on the other hand, the accused in the present case, all 5 of them, had antecedents, had multiple complaint filed against them. Even the principal has stated in his own statement, again the statement stands not objected from the side of the defense, states accepted. They had to categorically object to all the statements as they have not, so it stands accepted by them. So as it proves the point of the accused having a past history of being indulged into petty crimes, theft and alcoholism, and always had the point and always had that hunger to be rich by any means necessary, thus proving the intention of kidnapping. Secondly, Your Lordship, the word kidnapping does not mean it has to be from point A to B. While in that point also kidnapping can take place. The moment I take back my consent from a trip, but I am still forced to be in one, that is where the word kidnapping can be interpreted. As the statement of the service boy clearly states, that when I went inside, he was asking for help. I thought he was in distress, and yet they were not letting him go. As the post-mortem report, Your Lordship, clearly states, and also stated by the service boy, the people were holding his hands and making him pinned down in a very strict manner. The point 2, sub-point F, post-mortem changes and other appearances of the body. Marks of strangulation around the neck, injuries made on the forehead. Your Lordship, for the court's record, strangulation justifies the point of O marks that are found on the body. As the report clearly states, it is strangulation, thus proving the point it was intentionally done. One cannot make sure that the person himself is strangulating oneself. Except for that, Your Lordship, the point, if we take into consideration, the wrists are dislocated, leading to hemorrhage. When someone is, apologies, Your Lordship. Shall I continue, Your Lordships? Indeed, obliged, Your Lordships. The wrist stands dislocated, leading to hemorrhage. Your Lordship, hemorrhage takes place when your internal veins are tampered with. And once it is dislocated, it is really a huge problem to stop an hemorrhage. In this situation, it was also one of the things that led it to the 1 minute extension, Your Lordship, to conclude the entire arguments to, but as we are the prosecution, we have to prove everything beyond reasonable doubt. Much obliged, Your Lordships. Taking into consideration, Your Lordship, the FIR proving all the sections one by one. Your Lordship, the first section is 103. 103, that is murder. There are 2 things to be. The actus reus in this situation was, Your Lordship, that they pinned him down because they were aware if we leave him free, he will be a problem for us because we have called for ransom. The second thing was, Your Lordship, the conspiracy. If you intended to go to a Durga temple, you should have gone to the Durga temple. You planned a plan A, you did not take care of the plan, and you again went to a place else. That means you had an inherent bad intention about the same. The third thing is kidnapping for ransom. There stands the accepted even from the side of the defense that there was a call for ransom. And they did not object that who was the person calling for ransom. Thus also accept the fact that their own accused were the people who have called for ransom. The third thing is organized crime. The interpretation of organized crime is, Your Lordship, any kidnapping that is done for ransom or murder can be included in the interpretation of organized crime. Both of them took place, thus proving the point of section 111 stands true. Except for theft of a vehicle, as I've objected then and there, as it was not an informed consent from the side of the owner's, the vehicle's owner, as he was the person who was riding, Raju was not a legal owner of the vehicle. And he had no proof whatsoever that person is, or who is the person whose car he is driving. That means he had a malice, and he also has past antecedents, Your Lordship, to prove that he is an habitual offender. Except for that, Your Lordship, the fake credit cards proves the point of him making an entire thing to make sure that no traces are left behind. By concluding, except for those two things, wrongful restraint is when you are restraining someone to go out on their own freedom. As someone is pinned down, it is the definition of wrongful restraint. The last thing was voluntary causing hurt. As the post-mortem report clearly states, there are injuries on the forehead, there are boils on the back, and there are multiple rib injuries and the chest injuries. That justifies the point that there are voluntary hurts caused to the victim. Your Lordship, the concluding point is, the deceased in this situation had a promising future. He was mere 21 years old, who had a financial backing to make sure he achieves the stars. Yet, the greedy people killed a promising career just to make sure that they live a lavish life. Having everything from bad character to antecedents to mens rea to actus reus, they should not be set free. People who are in college and are getting education are doing such crimes shouldn't be the part of the society, and definitely shouldn't be given a leniency in the statement because they took a life of someone who definitely would have been an asset to the country. Now the honorable courts, the prosecution would like to pray their own side. That is to first sentence all the accused to the maximum sentencing under all the following charges, except theft for vehicle should be charged specifically towards Raju, as he was the one on record stated, I bought the car. I was the one who was driving the car, thus proving this point. Except for that, all the other things should be charged in its maximum, and if the victim compensation scheme shall by liberal interpretation be applied on the same case, should the parents be given some compensation for losing their own old stick in the old times. And the counsel for the prosecution will be highly to it from the side of the prosecution. Much obliged, Your Lordship. We would like to conclude if there are no points of rebuttal from our side after the closing statement of the defense. Much obliged, Your Lordship.
Your Honours, counsel seeks permission to present the closing arguments. Your Honours, as accepted in the very first part of the trial by prosecution themselves, that Your Honours, as accepted by prosecution in the very first part of the trial itself, that there is no direct evidence present in the instant case. The whole case is relied upon circumstantial evidences. And Your Honours, for that I am very thankful, in fact, for my learned prosecution, that they provided you with the case law, which mentions the very important factors when circumstantial evidences can be relied upon. Your Honours, if I may please again remind this honourable court that they should exclude every possible hypothesis except the one is to be proved. And Your Honours, in all human possibilities, the charges or the accusation should point out to accused and accused only, Your Honours. In this case, we humbly submit to this honourable court that prosecution has completely failed to establish a proper chain of evidences which will point the guilt towards accused, Your Honours. Your Honors, if we deal with this section by section, which are sections charged on my clients, Your Honors, the very first and grave section which is charged is section 103 of murder. Now, Your Honors, they talked about mens rea and actus rea. They completely failed to establish any mens rea or even motive from the side of accused, Your Honors. On mere being poor, Your Honors, it is not to be accepted that poor people will ultimately kill the rich person who are with them. This cannot be a ground of mens rea for the murder, Your Honors. There must be some planning, plotting, even the motive if we have to establish, Your Honor. Just because my clients are poor, it cannot constitute as a mens rea to kill someone who is rich, Your Honors. Further, if we talk about the actus rea, Your Honors, the high reliance of prosecution were on the last seen theory. Your Honors, last seen theory can be relied only when the time lag between the time deceased was seen last with the accused and the time of the murder is narrow. This time lag must be narrow to rely on the last seen theory. Now, in instant case, Your Honors, the post-mortem report which is submitted does not mention the time of death of the deceased, Your Honors. Also, the investigation officer, while in his cross-examination, was highly confused about at what exact time the deceased was dead. Your Honor, deceased was last seen with accused at 21st of October. His body was recovered at 24th October. This time lag between the last seen with the accused cannot be relied upon, Your Honors. Further, Your Honors, the post-mortem reports does mentions the very grievous hurt signs on the body of deceased, Your Honors. And we are very sorry that Suhas had to face all this. But those marks, those injuries, those hurting injuries are nowhere linked with the accused, Your Honors. How the prosecution has failed to prove that those injuries were caused by the hurt by accused, hurt by my five clients, Your Honors. Your Honors, the death was caused by strangling from the nylon rope. Your Honors, prosecution failed to establish that the strangling, that the nylon rope was in possession of any of accused at the time of death. As Your Honors, there is no direct eyewitness or nor even a forensic evidences which proves that this nylon rope strangling was done by my clients, Your Honors. And again, for the murder or even for the kidnapping and abduction, they have relied upon the testimony of service boy in instant case, Your Honors. Service boy in the last statement of, and they have not recalled the service boy again, Your Honors, in last statement of closing argument, he himself stated that the incidents which he saw was so casual in nature that he forget about it after 5 to 10 minutes, Your Honors. This casual incidents cannot be compared with the grievous charges of murder, Your Honors. To prove kidnapping, Your Honors, there must be a very important element, and that element is of element of force, Your Honors. In instant case, Suhas voluntarily agreed to go on this trip, Your Honors. In the whole chain of events which happened in instant case, there is no mention or no proving by prosecution side that Suhas anywhere retaliate about his presence with the group, Your Honors. He was voluntarily present with for the whole time, Your Honors. So the abduction or kidnapping cannot be charged against my clients, Your Honors. The ransom call, which was made by, allegedly made by my clients, Your Honors. The call records of the father who received the ransom call or the call records of the BSNL cards which was in possession of accused are nowhere submitted to this honorable court. So prosecution has failed to conclusively prove that the ransom call which was received by father of deceased was made by my accused, Your Honors. And Your Honors, the ransom money which was transferred by father of deceased was transferred to an account which is named as Miss Vibha. Now, Your Honors, prosecution has completely failed to establish the link between the person Miss Vibha who received the 15 lakh of ransom with the 5 accused who are charged in instant case, Your Honors. So neither they have established that the call of ransom was made by accused, neither they have established that the money for ransom is deposited in the accounts of accused, any of the accused, Your Honors.
Your Lordship, there stands 2 major objections. While closing arguments, you cannot add anything except for what you have already stated. Nor the prosecution nor the defense ever in the entirety talked about Miss Viva, nor the defense ever in the entire arguments talked about post-mortem report. Now, using the post-mortem report to justify their closing arguments is not allowed. It is barred by law because closing statement has to be the summary. Your Lordship.
Your Honours, in meantime, if may I can. Your Honours, because there is restriction on taking witnesses for the time being, they have only took 3 witnesses. But Your Honours, we have the statement of IO, we took the statement of IO. Your Honours, the post-mortem report is submitted to the Honourable Court and the defence side. So we have every right to argue about the post-mortem report, even if the chief of post-mortem is not presented in the witness. Much obliged, Your Honours. Your Honours, about section of organized crime. Your Honours, for the sake of arguments, for an instance, we even consider that the organized, that all these 5 people were organizedly done this ransom thing. Your Honours, still, it is an isolated act, Your Honour. For organized crime, there must be a syndicate who is constantly working about any financial crime. Your Honours, prosecution has failed to establish this thing that all 5 accused or any accused was part of any syndicate who is doing constantly or repeatedly an financial crime, Your Honours. Therefore, section 111 of organized crime cannot be charged against my clients. Your Honours, about section 126 plus section 115, which is wrongful restraint and voluntarily hurt. Again, Your Honours, the only reliance about these sections are placed on the testimony of service boy, Your Honours. There is no evidences presented to prove that there was wrongful restraint, Your Honour. Suhas was never restrained by any of accused. He always was voluntarily involved and he always did everything voluntarily. Hurt, whereas Your Honours, there must be an support, hurt must be supported by any medical evidence or any eyewitness testimony. Now, as we all have come to conclusion, there is no eyewitness testimony and the medical report is nothing but funny, Your Honours. As there is no fingerprint examination, there is no DNA examination conducted in this whole matter, Your Honours. Therefore, the injuries or the hurt caused to deceased nowhere is linked with accused, Your Honours. And the last 3 sections, which is section 303, 305 and 61. Your Honours, 303 and 305 is theft and theft in vehicle, Your Honours. Whereas theft is only charged for the credit cards. Now, Your Honours, this credit card as alleged by the prosecution are of ownership of Harshad Mehta and Zafar Ali, Your Honours. The statement of these 2 people are not on record, Your Honours. Your Honour, freezing of credit card is so easy. If the credit cards are stolen by accused from these 2 people, they would have called the bank and freezed the credit card within 1 hour, Your Honours. Credit card is freezed. Accused used this stolen credit card for 4 days, Your Honours, and there is no report of any stolen credit card or even stolen car, Your Honours. Therefore, the charges of theft and theft of vehicle cannot be placed against my clients, Your Honours. Therefore, it is most humbly submitted before this honourable court, Your Honours, that prosecution has failed to prove guilt beyond any reasonable doubt, and defence submits that evidence presented by prosecution is riddled with contradictions, gaps and absolute procedural lapses, Your Honours. None of the evidence conclusively established the guilt of accused, either individually or collectively. And for this, Your Honours, in light of all the issues raised, argument advanced, we pray to this honourable court to please acquit Raju Munir, Manu Singh, Dilip Sutar, Shantanu Murthy and Prakash Hegde under all charged section of Bharatiya Nyaya Sanhita. Pass any other order which this court deems to be fit in justice, equity and good conscience, and all of this is humbly prayed to this honourable court. Much obliged, Your Honours.
Your Lordships, there stands, first I would, Your Lordship, there stands one interpretation of relevancy of facts. As I would like to apologize and plead ignorance on the grounds, it is not barred by law, but it is settled norm that while giving closing arguments, you cannot add anything. Apologies to both the sides, to the Honorable Bench and to the defense. Except for that, I would ask the Honorable Courts to please grant us rebuttal, as there are some specifications added up. Much obliged, Your Lordships. Indeed, Your Lordships. First, Your Lordship, the problem was that they have said that the chain of evidences or the chain of the entire scene was not proved. We proved from the initial point that Subhash went by consent. But when he went to the second hotel, he revoked the consent when he was pinned down, as corroborated by the statement of the service boy. The second thing was, it was with the service boy when Subhash was last seen. And if you are a good friend, as Raju stated, he was our good friend, you should have directly went to the father first to prove that we cannot find him. As the last statement given by Raju was, we were going to tell him that his son was missing. And the previous statement was, we thought he went home. Thus proving the contradiction and proving also the point that he himself is not confident was it that he went by consent or he was missing. The second thing, Your Lordship, the point of murder, the actus reus, mens rea, both stands proof. The actus reus in this situation was, they made sure the entirety of him to be in the car, going to the hotel, being pinned down, being strangulated is what is actus reus. The mens rea was, they already called his father for ransom. If he would have been set free, the concluding points except for that would be, some of the points, as forensic takes time, Your Lordship, it is still under investigation and would be submitted to the honorable courts within time. The circumstantial evidence is supported by the Sharada judgment. As it said, it had to be hypothesis of one single argument. I have categorically proved first murder, then organized crime, thus proving everything aligning to the circumstantial evidence. Except for that, the person who will make offer to pay amount and ransom, as it was not stated by any of the people, nor the side of the defense, nor by us, that what was the account that it went to, and it was not even objected or rebutted from the side of the defense. They accepted the fact that it went to somewhere around their own people, nor they did accept that you called his father or not. Not Raju on record stated that we did not call his father. But on the other hand, he said we called his father. That means it can be construed that he called his father for ransom, and it was not rebutted. And by concluding, Your Lordships, much obliged.
Your Honor, if I may get 30 seconds, they are misleading. Sorry, Your Honor.
You have time.
Your Honor, they are misleading the court. They said that Raju accepted that he went missing and then said that he was voluntarily gone. Your Honors, Raju firstly said that he voluntarily gone at night. When they couldn't find him, then they thought that he is missing, Your Honors. Further, we did objected on the point that the money was transferred to Ms. Vibha and not to any of accused, and she is not linked with it. Your Honors, all the facts which in rebuttal they stated are not be submitted, Your Honors. So it might not be taken on records, Your Honors. Obliged.
thus proving everything aligning to the circumstantial evidence.
Hello.
Yes.
On behalf of sister and myself, I congratulate the organizers and the participants for this session. This trial, what we feel, is more of a theoretical nature than what we practically see every day. So, but then, you being student and considering that aspect, we feel that both the sides were equally tough to be judged, but then someone has to win, and therefore there will be a winner who will, that will be announced at appropriate time. That is what we were told. What we feel that we should give message to you, you being the future of this fraternity. The first and foremost is that you should be well versed with law. A prosecution story based on circumstantial evidence. The fundamental of the trial is that it is the prosecution who has to prove the case. There is nothing that you would find that the accused has admitted this or admitted that, or the documents exhibited. Documents will be exhibited. But then entire burden is on the prosecution to prove. When it comes to examining witnesses, to start with, you won't find Gita in the court. So there is no oath by having your hand on Gita and the manner in which it's all, that's fine. Therefore, I said it's more of a chief and cross. Both are skills. You you have certain limitations when you are conducting chief examinations. You cannot put leading questions. Leading question is one where you may say that the answer to the question would be definite. What happened on a particular day is not a leading question. But then, did you call so and so is a leading question. Where there are more than one answers or possibility of, entire day, many things could happen. So that way, you will in due course understand what leading question is and what are the limitations in chief examination. It is not that you cannot ask leading question in chief examination. With the permission of the court, you may. Therefore, you will have to read every aspect of this, the niceties of law. Now, in the evidence of investigating officer, when there was cross-examination being conducted, you found, prosecution number 1, that as regards timing of death, there was some confusion in the mind of the investigating officer. In the night of 21-22 or 22-23, if there is certain mistake committed, then in the re-examination, it is the duty of the prosecution to get this discrepancy, ambiguity clarified. This aspect of re-examination we find every day is missing actually in practical trial also. Please have thorough study on re-examination. Correct? Then in cross-examination, defense has to be very careful. The first basic of the criminal trial is that from the point of view of defense is that if the case is accepted as it is without putting a single question in cross-examination, what would be the result? Now, if entire theory is based on the statement of the father of the deceased, father hasn't seen anything. Whatever knowledge father has gathered is a hearsay knowledge. His evidence is inadmissible. So even if the defense doesn't put a single question in cross-examination, would not make any difference. Firstly, inadmissible evidence should not be allowed to be deposed. That is the duty of the court as well. Another aspect is the duty of the prosecution is not only to prove guilt come what may, but to be neutral. It is the duty of the prosecution to point out to the court certain important facts which are in favor of defense, which defense failed to point out. To that extent it goes. So far as coming to the proof of a fact, it is always better and advisable before you commence a trial to read the definition of proved. You may read it right now. If you have a book, you may read definition of proved fact. What is that? Do you have that book, defense? The section 3, I hope, the Evidence Act. Huh? Oh, anyone, any will do. Have a mic and just let us read what is proved fact means.
Your Lordship, the word proved, a fact is said to be proved when, after consideration the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it exists.
Correct. After taking entire thing into consideration, if in all probabilities a prudent man feels that it is what actually exists is a proved fact. What happens practically also, that this terminology proved beyond reasonable doubt is carried so much so far that one goes to proved beyond shadow of doubt category. You just have to prove beyond reasonable doubt. That doesn't mean it has to be beyond shadow of doubt. Circumstantial evidence, you have rightly pointed out the law laid down by the Supreme Court. These 5 factors are essential. Whether that has been done. One of that is, you said so many times last seen theory was. For last seen theory, you may then read section 106 of Evidence Act.
Burden of proving fact, especially within the knowledge. When any fact is especially within the knowledge of any person, the burden of proving the fact is upon him.
When a fact is within the exclusive knowledge of a person, the burden is upon that person. When it comes to last seen theory, when your witness says, the hotel boy, that he had seen the accused, 2 of them, pinning the deceased with the bed or down, which has been in a way brought on record in the defense as well. Defense ought not to have put up those questions that whether you entered the room, you did not. If you get things in cross-examination, then no further evidence is required. You have, in a way, brought it on record in cross-examination that the hotel boy had seen this. Now, if that is a last seen theory, then the burden would shift upon the defense to prove as to why in terms of section 106, and if that is not disclosed by the defense as regards death of that person, then the presumption will be against the defense. If they fail to prove, and then so therefore, we said that one will have to be thorough with law. That would save lot of time and lot of questions unnecessarily put up to witnesses by both the sides. So you will be learning all these things. It's too early to expect these things from you. Even today we are learning, we come to know from the people like you only, advocates. It's ever learning process. So be prepared for that. Then will you come to know what question should be put up, what question should be avoided once something is brought on record in one's favor. The purpose of trial is to find out the truth and truth, nothing else, and for that purpose the court has ample powers. The court can put any question at any time, relevant, irrelevant. That is what section 165 of Evidence Act says. And then there is a theory of approval. Approval is something that is to be done before or even pending trial. But then the prosecution witnesses completed, defense completed, and then suddenly the accused is saying, confession has its own law. 164, under section 164 of CRPC, confession is recorded. Confession before police is not admissible, and so many things. Correct? So whether criminal or civil, when it is a trial court, you will have to be thorough with facts as well as law. Then there was a valid point from defense that after the second stay in the hotel, there was a gap of 48 hours or so. Whether that would make a difference is another thing. But then because your approver had put up a different theory, and if he has not supported you, you cannot, you said that dismissed, you cannot really dismiss the witness. Your duty was to cross-examine him. Once your own witness turns hostile, hostile means what? The statement which was given, statement is not given before the advocate. You cannot say that statement was given before us. There cannot be statement before. Either the statement will be before the investigating officer or before the court. To impeach the credibility of the witness, his previous statement will always be taken care of. You cannot really object. The statements recorded by police are never exhibited. Statement recorded by police are never exhibited. So the argument that the statements were exhibited or not exhibited and therefore defense could not take resort to is incorrect. Defense will always try to impeach the credibility of witness by pointing out or by knowing what he had earlier stated. That impeachment has to be material. It's not that there will be certain contradictions and certain omissions. That would not make any difference. It has to be material contradiction, material omission to then impeach the credibility of the witness. Okay. Trial. So you are a final year student? No. Okay. Then which semester you are in? Fourth year. Fourth year. So you had occasion to actually witness a trial? No. It's always advisable. Yes. Wherever you intend to practice, whether the trial court or high court or Supreme Court, it will always be advisable to have time spent before the trial court for some time, at least a year. That is the court where you get to know how things, means practically the difficulties faced by the prosecution, by the witnesses, how things proceed, and how one should then, that would enable you to, appreciate the evidence, the practicalities in the life, how witness enters witness box. It's everyday affair for the advocates and a judge. For witness, it's altogether a different scenario, different picture. When he enters witness box, many of the witnesses, most of the witnesses, literally sure. It's difficult to, face the advocates, the court atmosphere is such. Witness is bound to commit mistake, bound to commit mistake. So it's the duty of prosecutor to make him comfortable. You can offer water also with the permission of the court. It's also the duty of the court to make witness comfortable. To get the requisite material from witness's mouth is something is of extremely important nature so far as prosecution is concerned. We'll just tell you one small example. The trial was of murder only, different places you will have different psychology, different mindset of the people. I was in Mumbai also, where I tried MCOC cases, the hardcore criminals. My sister has also tried such cases. Huge difference between the commission of crime in the rural areas and this organized crime. Organized crime, she was right in saying that for organized crime there has to be syndicate and all those things. And then that a couple of charge sheet having monetary aspect. So Mumbai, the witnesses, the crime is altogether different. Now, when I was posted at Bede, the trial was 302. Husband committed murder of his own wife for 200 rupees. That 200 was required for consuming liquor, which she denied. So he poured Rockhill and set her ablaze. As against when I was in Mumbai, there was a murder for ransom of 5 crores, a cold-blooded murder, not of the hotel owner, but of the watchman standing in front of hotel. Just to tell the owner, you see, this is what would happen with you if you don't. Now, when the witness in the Bede district, when he entered the court, like the entry was from left side, and usually we do have, though looking here, we have some side there. He removed his chappals, bow down, and then entered. For him, it was a temple of justice. This, at least I didn't find it in Mumbai. A practical approach. Okay, sir, fine enough. Yes, sir. No problem. We'll come here, give his evidence, and we'll go. Here is a man, old man. And what for he is coming here? To depose against his son-in-law, to say that my daughter was killed. Now he enters witness box, and then prosecutor says, yes, काय झालं त्या दिवशी सांगा. Look at the tone. He started crying. काय सांगू? काय सांगू? माझी मुलगी गेली, काय सांगू? अहो ते जाऊ द्या हो. मुलगी गेली ते ठीक आहे, पण ते सांगावं लागेल ना कोर्टाला. नीट सांगा काय झालं. Then I said, hold on, make him comfortable first. Get this stool, let him sit, old age person. So he was just saying that माझी मुलगी गेली आता काय सांगू, माझी मुलगी गेली आता काय सांगू. So one will have to understand the facts of the case, what he is here for, and then prosecutor has to, in such circumstances, get out of his mouth the entire incident. That is how the court will look at whether the guilt is proved or not proved. So one has to be that sensitive to all these aspects. It's not that someone will come and then you will go on asking. It's everyday affair for you, not for that gentleman. And in similar is in cross-examination also. I'm sorry, while you are defending the accused also. You may not say anything. Accused is not supposed to prove otherwise. It is mainly on prosecution. But then whoever is representing prosecution should always see and adhere to section 3. It is not a big deal to prove the facts. Not shadow of doubt, beyond reasonable doubt, sufficient. Correct? So, and there are so many things to be spoken about. The message is, you should be thorough with facts and law. Then only you will be able to get what you intend to. Right? So, so with this, for concluding remarks, I will hand over mic to my sister judge. And wish you best of luck. Thank you for inviting us here. Thank
you. Good morning to everybody. My brother already spoken on what should be the students' approach to the case and how it should be conducted. First of all, I thanks to principal and staff, faculty members that we have been called here to conduct the moot trials. That is national level trial moot court. In fact, we are the part of this institution. We are celebrating 100 years. And I was the student of first batch of 5 years. And I'm proud. And I feel proud that although we were of the first batch, all faculty members have taken so much efforts for us. Even moot courts were conducted. It was experiment on our batch, but still I am proud to say that many of us are holding big post and high post in the institution like Vice Chancellor in the university, IAS officers, head of the departments, income tax practitioners. So I am very much thankful to the institution for giving such opportunity to again come to the institution and say some few words. Thank you very much. I extend my best wishes to all of you in future also. And what he said, to attend the court is the best approach to study. In fact, when we have, I was elected as a district judge, I was not having much experience in criminal matters. Only after sitting on dais, I came to know how the complaint is registered, what is written in the complaint, how that PSO register the complaint. These small issues we learn after we actually go through the material, case material. So I hope that you will induct these, cultivate these habits in you. Thank you very much.
We are very thankful for the Honorable Bench for guiding the students and addressing the assembly with their practical insights. We are very fortunate that the Honorable Bench could be a part of this event and inspire the upcoming generation of lawyers.
As we draw this remarkable event to close, I would like to invite Master Advait to deliver the formal vote of thanks.
Good morning, respected days, Honorable Justice M.S. Zavarkar Ma'am, Judge High Court, Honorable Justice A.L. Pansare Sir, Judge High Court, Shri Dinesh Shendam Sir, Senate Member, respected Principal of our college and Head of entire BACL family, Dr. Ravi Shankar Moore Sir. It is both an honor and a privilege to deliver the vote of thanks for first ever National Trial Advocacy Competition of 27 Justa Causa. First and foremost, I extend my heartfelt gratitude to our guest, Dinesh Shendam Sir, for gracing this occasion with your presence. A sincere gratitude to our Honorable Judges, Honorable Judge M.S. Zavarkar Ma'am, Honorable Justice A.L. Pansare Sir, who have contributed their time, experience, invaluable feedback to make this competition a truly enriching experience for our participants. Your presence adds immense credibility to this event. To our participants, you are the heart and soul of this competition. Your dedication, preparation, and spirited arguments have been truly commendable, showcasing the brilliance and potential of future legal minds. A special mention to Dr. Praveena Khobragade ma'am, Dr. Adhara Deshpande ma'am, teacher coordinator Brunmay Kukade ma'am, mentors Sakshi ma'am, Brinal ma'am, who have guided us through the process of and supported us at every step. I would like to express my deepest appreciation to my fellow volunteers, team coordinators, courtroom officials, and volunteers who played roles of accused and witnesses. PSI, Sampada, Sudiksha, Disha, Tahura. Accused, Manthan, Taha, Tanmay, Anuprabha, Jayesh, Armiyan, Arfat, Srirang. Witnesses, Rutuja, Komal, Sagarika, Disha Vadkar, Sanjana, Bulbul, Sandas, Tanvi, Gayatri, Komalikhare, Anshara, Mihika, and all others who worked tirelessly and contributed to this event. Lastly, to our audience and supporters, thank you for all your enthusiasm and encouragement. Last but not the least, the backbone of Trial Advocacy Committee, Mayuri Upre and Nikur Chanore, without whose help this event would not have been a successful event. Thank you all once again and have a great day.